the cell site through to the wheat sheaf, there's a clear line of sight path. The measurements I made would indicate that the call could easily have been made up from the pub, which corroborated Jack Worm's alibi.
The applicants submit that Essex Police's interrogation of the victim's mobile phone handsets was inadequate, particularly the attempts to interrogate Tucker's handset, of which DC Miller stated, "I was unable to power up the telephone due to heavy blood contamination. I was therefore unable to extract any information from the telephone." As a result of this admission, the Commission arranged for handsets attributed to Tucker, Tate, together with their associated SIM cards, to be interrogated using modern mobile telephone forensic techniques. The testing was carried out by DC James Luck, Senior Technologist at the Metropolitan Digital and Electronics Forensic Service. Dr. Luck provided his results to the Commission on the 19th of April 2010, and these were disclosed to the applicants on the 6th of May 2010. Dr. Luck's interrogation resulted in the retrieval from the memory of each of the two handsets of the telephone numbers for dialed, received and missed calls, although he could not definitely say which category of each call of the numbers fell into. Unfortunately, Dr. Luck confirmed that neither of the handsets was capable of storing the times or dates of the calls. In those circumstances, the Commission does not consider the results of Dr. Luck's interrogation are capable of assisting in the determination of whether either of the victims made or answered telephone calls after 1844 on the 6th of December. Having received Dr. Luck's results, the Commission considered the only conceivable way of making further inquiries into the dates and times for the dialed and received calls to and from the victims' mobile phones would be to analyse the itemized billing data for each of the telephone memories which were retrieved from the memory of the handsets. Consequently, the Commission has analysed itemized billing for the following telephone numbers. None of the itemized billing which had been analysed had received any post-1844 calls to either of the relative victims. The Commission has been unable to locate any itemized billing data for the following telephone numbers. Having considered all the available data and the representations of Wome, Steele and Bowen on this issue, the Commission takes the following view. There remains no evidence of any calls made or answered by any of the victims after the 1844 call. There is nothing in the applicant's submissions which is capable of giving rise to a real possibility that the Court of Appeal would overturn the convictions in this case. The applicants have referred to the two phone calls made by Steele to Womes at 1803 and 1809 on the 6th of December 95. It is pointed out that the Crown claimed the calls were made from the car park of the Halfway House public house. However, both of the calls were served by the Childerditch Beacon, and it is said that this would have not have been possible if they had been made from the Halfway House. The Commission observes that this point was analysed at trial. It is also featured in Steele's grounds of appeal for the 1999 application to the Court of Appeal and in David Bristow's expert report for the 2006 appeal to the Court of Appeal. The submission is therefore not new for the Commission's purposes and cannot form the basis of a referral to the Court of Appeal. It is submitted that Mr. Bristow's tests have now proved that it would have been impossible for Tate to receive the 1844 call from Sarah Saunders via the Wickford transmitter if he was located in or near to Workhouse Lane at that time. This submission would appear to be based upon testing which Mr. Bristow carried out prior to trial in 1997. At paragraph 4.4 of Mr. Bristow's 2007 report, he states, "More recently, I have carried out further analysis and tests on the service provided by cell identity 1404 from the Orange cell site, Wickford. However, Mr. Bristow does not give any specific details of the further analysis and tests that he has carried out, except to mention that he has carried out a study of the topograph, which shows there is no line of sight path between the Wickford cell site and any part of Workhouse Lane." The Commission does not consider that there is any new evidence on this point which was not available at the time of trial in 1997, and at this time the appeals to the Court of Appeal in 1999 and 2006. In any event, although Mr. Bristow was not able to pick up the Wickford transmitter when he carried out tests in Workhouse Lane in September 1997, the Commission does not consider that this shows it would have been impossible for Tate's phone to have picked up the Wickford transmitter in December 1995. The Commission observes that it was recognised at trial, and then again before the Court of Appeal in 2006, that it was extremely difficult to replicate the exact conditions which would have existed for mobile phone usage in the area in question on the evening of the 6th of December 1995. As the Court of Appeal explained in 2006, it is exceedingly difficult to identify the variable conditions prevailing on any particular previous occasion. Thus, one cannot say whether any particular call is more likely to be routed to one cell site than another. All that can be said is whether it is possible for it to have happened. When giving evidence at trial, Mr. Bristow acknowledged that variations in any of the following factors might have some effect in which beacon calls were routed through on separate occasions: erection of buildings, growth of foliage, the type of handset usage, the orientation of the handset during the call, including position within a vehicle, the presence of other motor vehicles, the prevailing weather conditions, the precise geographical position and elevation above the ground. Mr. Bristow added, "I am the first to admit that mobile phone evidence of this kind is an imprecise art." On appeal in 2006, the Court of Appeal emphasised another important variable, namely, each cell site has only so many available channels. If all the channels on the cell site are being used by other callers, then the computers will automatically switch the call to another cell site. Thus, whether a call is routed to one cell site or another will be affected by the volume of telephone traffic at this particular time. Volume and telephone traffic is particularly variable and unpredictable, but it is often at its heaviest during the evening rush hour. When giving evidence at trial, Simon Collins, a telephone expert called by the prosecution, stated, "Trying to plot where people are by mobile telephone evidence is near enough impossible. You are dealing with likelihood and possibilities, and it is very complicated." For all of these reasons, the Commission does not consider that there is a real possibility that the Court of Appeal would find it to have been impossible for Mr. Tate to have received the 1844 call via the Wickford transmitter if he was in Workhouse Lane at the time. Even if Bristow's opinion regarding the 1844 call was accepted, however, the Commission does not consider that this would advance matters significantly. Mr. Bristow's conclusion in relation to the 1844 call is, when Pat Tate received a call from Sarah Saunders at 1844, he might possibly have been in the Rettendon area, but he could not have been in Workhouse Lane, either at the beginning of the call or at the end of the call. The Commission takes the view that if Mr. Bristow was correct that Tate was in the Rettendon area rather than specifically in Workhouse Lane at the time of the 1844 call, this would not raise a real possibility that the Court of Appeal would overturn the convictions. The Commission acknowledges that Mr. Nichols' trial evidence was that Mr. Steele told him that Tate took the 1844 call when they were in the lane, but the Commission notes once again that Mr. Nichols was given a second-hand account of what he claimed to have been told by Mr. Steele, and any alleged discrepancies must be assessed in that context. The applicants seek to rely on the beacon data in respect of Womes and Nichols for the 6th of December 1995, which shows two short calls were made by Womes to Nichols at 1859 on that date. The applicants submit that this reveals a discrepancy in Nichols' account of events, which is only referred to one telephone call from Womes at 1859. The applicants add that for both calls to register on the cell site beacons, Nichols would have had to answer them by flipping open his phone each time. The Commission has considered this submission, but observes that Nichols was cross-examined at trial by Mr. Lederman QC about the number of calls which he remembered receiving from Womes. Womes has acknowledged this in the course of his communications with the Commission. This point, therefore, does not constitute new evidence or argument for the Commission's purposes. In any event, the Commission also notes that Wholmes, in his own trial evidence, insisted that he only made one call to Darren Nichols at 1859. In his submissions to the Commission, Wholmes argues that the reason Nichols referred to one 1859 call rather than two was because he was being coached in his account by his interviewing officers who were working from a telephone action pack. The action pack was drawn up from billing data, so it would have only referred to one call. The shorter of the two calls was too brief to have been charged by Wholmes' phone company. The Commission has considered this submission, but takes the view that this is pure speculation. The Commission has seen no other evidence that Nichols was coached by the officers in this part of his account. The beacon data reveals as a fact that two calls were made. It was open to both Wholmes and Nichols to give the recollection of how many calls there were, and they both did so in their evidence at trial. The Commission takes the view that this submission does not give any rise to the real possibility that the Court of Appeal would overturn the convictions if this case were referred.